Hey everyone, hello. Ever since the SJC ruling came out a few days ago, I wanted to take some time, look at the documents, and then put it all together for everybody in the group. I've been receiving messages, phone calls. A lot of people are very concerned about this ruling, and as I'm going through it, I feel like there still is perhaps a light at the end of the tunnel. Some people are gloating and doing their statements, acting like this is a victory, but this is definitely not a victory. Ideally, it would have been great if the Supreme Court justices said that, you know, remove the preliminary injunction or the statues could rise, next month or within the next few months, whatever, and that's not going to happen, but that's okay. So let's go through this ruling. So right here on the top, we have, Claire Fitzmaurice and others versus the city of Quincy. Norfolk, May 6, 2026 to August 20th, 2026. Civil action commenced in Superior Court Department on May 28th. So it's going to go back to the Superior Court. Motion for a preliminary injunction and to dismiss were heard by William F. Sullivan. So that means that the William F. Sullivan issued a preliminary injunction to stop the statues while the matter was pending or going to play itself out in Superior Court. The city wanted put in a motion to dismiss that preliminary injunction, and it went all the way up to the Supreme Court justice, and they granted that application for direct appellate review of the preliminary injunction. And so here we have them: David Reich, Michael Cotto, Marianne Balsamo, Cynthia Roach Cotter, Salvatore Balsamo, Jay Tarantino, Conovery Bolton Valencius, Matthew Valencius, Cody Hooks, Kathleen Garrity, Lucille DeGravio, Cheryl LeClaire, and Martha Plotkin. And of course, Claire Fitzmaurice. And we have the mayor of Quincy. This is all the presiding, like the attorneys. And then here we have the beginning. So Judge Kafka introduces the dispute. The mayor commissioned two 10-foot bronze statues for the facade of the new public safety building. And, it's interesting how the court describes them right in the opening paragraph. St. Michael with angelic wings stepping on the neck of a demon, and St. Florian extinguishing an entire burning town with a single pitcher of water. Right away, the court frames them through Catholic theological miracles rather than the civic symbols of bravery. So that is very, very telling. The court also notes the 15 residents sued under Article 3 of the Massachusetts Declaration of Rights, which forbids the subordination of any religious domination. Now, look how the arguments are framed at the bottom of page 3. A Superior Court judge granted the plaintiff's motion for a preliminary injunction and denied the city's motion to dismiss. The city appealed, arguing the plaintiffs lacked standing and the statues are permissible under Article 3. And then when we get to this part, right, the city's brief refers to Michael, while the plaintiff's brief refers to St. Michael. The same is true for Florian, as the city used the term saint before each name in the contract commissioning the statues. We do the same. So again, they're really framing these statues, putting them through the Catholic lens, and even in the subtle language here, they are trying to poke holes in the legal argument that they are secular, right? And nobody's denying that they don't have Catholic connotations, but here the Supreme Court justices are pointing out that they were called saints on the contract commissioning the statues. So then we get to the taxpayer standings on the top of page 4, where We conclude that the plaintiffs have standing as taxpayers under GL 4053. We further conclude that the constitutionality of the statutes must be evaluated according to the framework we set out in Colo versus Treasurer and Receiver. Applying the comprehensive reasoning of Colo, we must conclude that the motion judge did not abuse his discretion in granting the preliminary injunction. Therefore, we affirm. So, what does that actually mean? What does it mean? The city argued that the residents had no standing, but under the SJC, they used Chapter 40, Section 53, which is the 10 taxpayer statute. That lets these 12 residents act like a private attorney general to challenge municipal spending. And then the court insisted that the case must be judged under 1979 Massachusetts Colo. So just to pause for a minute, the court did not stop these statutes permanently. All they did was affirm the preliminary injunction, which puts us right back to where we started. These statutes cannot go up until there's a full hearing, a full trial with witness testimony, evidence, and cross-examinations. The SJC didn't issue like a final decree. It just puts everything on pause until the matter plays out in Superior Court. But let's look at this. Look at this in Part 4, this footnote. We acknowledge the amicus brief submitted by Quincy firefighters, Local 792, International Association of Police Officers, Quincy Police Superior Officers Association, National Fraternal Order of Police, and Massachusetts Fraternal Order of Police, Islam and Religious Freedom Action Team, Jewish Coalition for Religious Liberty, Massachusetts Family Institute, Knights of Columbus, Pioneer New England Legal Foundation, National Association of Police Organizations, International Association of Firefighters. I mean, it just goes on and on and on. And it goes on to the next page, right? So we have, we're summarizing facts here, and we still have more people, more amicus and briefs from the Law and Social Action, Methodist Federation for Social Action, Sadhana Coalition, Society for Humanistic Judaism. I mean, the list goes on and on and on. And what's telling about that is, the footnotes run across 2 pages. Thousands of working police officers, firefighters, veterans, organized legal teams, they step forward to defend their patron symbols, really. And yet their sworn support, an entire coalition, probably over 1 million people, really. If you put all these people together, it would probably be close to 1 million. It's in a footnote, right? But when we move forward, you'll see the court gives immense weight to this 2-page letter by the interfaith group in Quincy, like signed by 14 people. I'm sure the interfaith does good work in the city, but why are they the moral authority to decide whether these symbols, are so offensive when we have a vast majority of people stepping out saying, hey, wait a minute, this is not right. It doesn't make any sense to me. You have about 1 million people in a footnote, but a 2-page letter from Quincy Interfaith somehow is the gospel. We go on. This is history about the statue and St. Michael. Now, this is interesting here. The parties have agreed that the statues are to be analyzed as a set and not to be separately. So I don't know if there was a conversation prior to about, if we're going to just try to keep St. Florian down, if we're just going to try to keep Archangel Michael down. But at some point they decided that they are together, they are a set, they're not separate. And so that is a pretty interesting footnote, that the parties have agreed that the statues are to be analyzed as a set and not separately. So then we have, we have page 7. Then they get into, after they spend quite a bit of time talking about the Catholic doctrine, as they call it. St. Michael and St. Florian have special significance to police officers and firefighters as symbols of virtue, bravery, and valor. They go into a few examples of tattoos, police awards. They talk about the Florian Cross, Florian Hall, International Firefighters Day on May 4th, which is St. Florian's feast day in Christianity. They talk about the poem for the fallen firefighters. First responders attest in affidavits that their statues represent the values they aspire to emulate in their profession. That's about it. I mean, we have pages and pages of talking about the Catholic iconography and tying them to miracles and faith, and yet we have just a paragraph. And you saw in the footnotes that there was much more than that. So I don't know if they decided just to go by what was in the original injunction and they didn't even talk about the amicus in briefs from a million police officers across the country. But that's pretty telling that there was only a few sentences about the secular meaning. Okay, so then we talk about January 2025, about the $761,368,000 in public funds. And then we start talking about, note here how they don't mention the whistleblower. I would like you guys to try to find the reference to the whistleblower. I know it's at the city council meeting. Ian Kane had talked about how it was a whistleblower, but it's been scrubbed from the newspapers. If you Google the whistleblower, sometimes it'll say, no, it was just good reporting. So I think it's very telling that somehow the whistleblower is being removed from public documents. I don't know. I don't know what that means. There's a conspiracy theory there. I mean, we still don't know who it is. I bet you Joe Murphy knows who it is. I bet Maggie McKee knows who it is. I bet Claire Fitzmaurice knows who it is. I bet there's a lot of insiders who know who that whistleblower is. So we talk about the local newspaper. Then we get to that February 24th meeting with the mayor's chief of staff. And after that meeting, interestingly enough, this is not in the brief, in these rulings, but they held that terrible meeting afterwards. They went over to the Universalist Church and they held an anti-statue shadow council meeting because they felt like they didn't get to speak enough at the council meeting specifically about the statues. They invited the press. It was filmed. It was on QATV. And it was pretty chilling. And there was a lot of anti-police rhetoric in there. There was some anti-Catholic rhetoric in that meeting. It was pretty sickening to watch. And here we go. Here we get to the 19 faith leaders from the Interfaith Network. This letter that they wrote has far too much weight considering all the supplementary material that is coming afterwards. Hundreds of city residents and at least one city councilor has publicly opposed the statues. I don't think it's hundreds. Online petition, 1,600 signatures. We have over 1,000 now. Grave concerns about the statues. Another councilor said statues are clearly contentious for everyone and that a bunch of constituents expressed their concern. And we know at that time, politically, we had the same group of activists trying to take down the mayor, the city council to get themselves elected. It was all fake, as we found out. Okay, so then here we go. May 28th, 15 city residents filed their complaint in the Superior Court against the city and the mayor, seeking a judgment declaring that the expenditure of public funds and planned installation of the statues violates Article 3 and preliminary and permanent injunctions prohibiting the defendants from expending more public funds on the statues and from installing them. They filed their complaint seeking a judgment, but they never have gotten that judgment. Just so everybody knows. Be clear here. On May 28th, 15 city residents filed a complaint, it's now 13, in the Superior Court against the city and the mayor, seeking a judgment declaring that the expenditure of public funds and the planned installation of the statues violates Article 3. Okay? They have not gotten that yet. They have not gotten that, and they won't get it at all, by the way. And preliminary and permanent injunction prohibiting the defendants from expending more public funds on the statues and from installing them. They did receive that. So the judge only granted them their preliminary injunction. Judge Sullivan. With the Quincy Interfaith Network, these people, I don't know what, I mean, just because they say that they have faith, I don't think they have faith. I don't believe it at all. I think writing a letter like that shows that you value a political agenda more than you do faith. The Interfaith Network of Quincy is part of the Hive Mind. They're heavily involved in the Universalist Church, and we know what that's all about. So it's interesting because it says here, confirmed, one plaintiff voluntarily dismissed her claims, another has moved out of Quincy and intends to move to dismiss his claims once the Superior Court stay of proceedings is filed. And only out of the 13, only 12 pay property taxes in Quincy. So it's 12 now. And you'll see why that's significant. So the plaintiffs have the standing under the 10 taxpayer statute. But before we get into that, I just wanted to remind everybody that so the Bully Alliance, the Hive Mind, the Reddit people, we're starting to talk about Colo in a few minutes, and we'll talk about how is it divisive plays into Colo, and these people in Reddit love to talk about Colo and how it's divisive, and thank you, Leah D. You're proving how divisive it is. This has been going on since way before May. This has been going on since February of 2025, and even before that with the petition for the raises. So these are all the same people. They're the ones that are the divisive ones. They're the ones that have been dividing Quincy with flagrant lawsuits. They've cost the taxpayers over $100,000 when it comes to the signature lawsuit. Luckily, the statute lawsuit is pro bono. But they are the ones that have been creating this havoc in the city merely because they want to aggravate the mayor so much so that he doesn't run for office, and then Motormouth Mahoney may be able to take over. I know I don't want that. The Weymouth resident, as they love to call me, the Weymouth resident is worried about Quincy. So there's that. So this divisiveness isn't because of me. As much as they would love to blame me that I'm the one causing the divisiveness, if anything, I'm bringing the community together. I'm bringing together the other side of the equation, the other side of the argument, the vast majority of people who have common sense and actually want the statues. That's what I'm doing. So let's get on to page 10, 11. We talk about the legal standing, which is the 10 taxpayer statute, which was something I didn't know. So Quincy originally argued that the taxpayers had no standing because over $761,000 had already been paid to the sculpture before the lawsuit was filed. The money was spent, the contract was executed, and the plaintiffs could not demonstrate that their future tax burden would increase, but the court rejected that, unfortunately. Justice Kafka wrote that because additional public money will still be required to transport, imagine this, transport the statues from Randolph Storage and affix them to the building's facade, that the future installation expenditures gives 12's taxpayers statutory standing to challenge the project. It's so funny because I don't know if I didn't read the filings close enough, but I had no idea about this 10 taxpayer statute, right? And I see so many people in city council meetings get up and say, as a taxpayer, to the point where it was like, it's annoying. It's almost like a sense of entitlement for you to act like municipal funds are your personal checkbook. And now I'm starting to understand where it comes from. They're acting like there's the 10 taxpayer statute where they can, this is what it says right here. We conclude that the plaintiffs have standing under GLC 4053, known as the 10 taxpayer statute. The 10 taxpayer statute provides that not less than 10 taxable inhabitants may petition a court to restrain a city from expending money for any purpose or object or in any manner other than that for which such city has the legal and constitutional right and power to expend money. So they're arguing that it's unconstitutional to put up those statues. So, as the 10 taxpayers, they have the ability to do this and they have the standing. So, they've established the standing, they've gotten their preliminary injunction, but that still doesn't mean that the statues are unconstitutional and they aren't able to go up. That doesn't mean anything. They have their standing as the 10 taxpayers. They got their preliminary injunction. The Supreme Court justices have affirmed it, and they've given their reasons at the end, and we will get to that. So, just in general, I think it's a very powerful loophole, if you will. I mean, these 12 taxpayers are able to halt an entire civic tribute to police and fire on a $175 million facility simply because the city still has to pay a little bit of cost to transport them out of Randolph and back on top of the building when they're the ones that halted it to begin with. They're the ones that have caused this, right? We could get into COLO. I'm going to get into it a little bit. At first, I thought COLO would be a good thing, but I guess it's not. So under COLO, so the Supreme Court Justice ruled that we have to look at this under COLO. COLO asks 4 questions. Does the government have a secular purpose? Does the primary effect advance or endorse religion? Does it cause excessive government entanglement? And the big one, does it cause political divisiveness? Now, the city did not want to use COLO. In my opinion, does the government have a secular purpose? Yes. Does the primary effect advance or endorse religion? No. Does it cause excessive government entanglement? No. And is it divisive? No, I don't think it is. I think there is the same activist network causing all this problem on purpose. We have certain political activists talking about creating political pressure and putting pressure on and making people uncomfortable on purpose. This is all manufactured outrage. It's all bullshit. But the city did not want to use COLO. 2022 U.S. Supreme Court decided Kennedy versus Bremerton, a famous case of a high school football coach praying on the 50th yard line. And the U.S. Supreme Court completely scrapped the old tests and ruled that religious symbols must now be judged by historical practices and understanding. So nothing else. They don't ask about secular purpose, primary advance of religion, excessive entanglement, political divisiveness. They just ask one question. What is the historical practice and what are the understandings? And if you look at Archangel Michael, St. Florian, right? What are the historical practices? Their secular purpose for police and fire. They're in front of their building, right? That's where they are. They're for them. And that's how they're understood broadly by millions of people worldwide. Quincy said, follow the U.S. Supreme Court, use the Kennedy history test, and our first responders will have their tribute. But the SJC said no. They want to use COLO. The Mass state constitution can be much stricter than federal law. So the city gave the Supreme Court of Massachusetts a big opportunity here to use the common sense Kennedy standard. And the SJC used the 47-year-old state precedent so they could just judge the political divisiveness and push back. And I think it rewards people like Claire Fitzmaurice and Sal and Mimi Bassamo and all those people that the louder you are and the more havoc you cause, I mean, you're basically being rewarded for your bad behavior, if you ask me. So Moving on to, going to scroll ahead. There's all types of stuff. We conclude that the plaintiffs have the standing. So we did not decide whether they also have constitutional standing. Okay, so now we're talking about the fact that they're brand new. Quincy pointed to established landmarks where religious imagery is legally permitted on public grounds. They gave a few instances, and the SJC rejected every single one of them. Basically because they're not new. So that Quincy statues are brand new, stand alone as sole decoration on a building. And they perceive Catholic iconography, and they believe that an objective observer will perceive them as government endorsement of Catholicism, but I don't believe that at all. And it's interesting because they say in the footnote, okay, if this litigation proceeds, the evidence regarding the secular significance of St. Michael and St. Florian, including in particular whether this secular significance would be understood by members of the public, may of course be further developed. So in essence, it's saying that as the litigation goes on, there might be more room to prove that members of the public can understand more what it's supposed to mean if this litigation proceeds. The problem with saying about they're new is that it's like an impossible catch-22, right? A monument is permitted if it has decades of history, but brand new statues honoring first responders that may have some religious iconography, right, are banned from ever being installed. So they never have that opportunity to create that history. So it's a barrier. So then now we go to the mayor's affidavit. So when we go to 31 and 32, the court looks at his affidavit, and the court says the city's argument is, hey, the mayor signed a sworn statement under oath that his only intent was honoring first responders, and this court should believe him. They shouldn't just be calling him a liar. And banning these statues just because they feature saints amounts to the government being biased and hostile against religion. And I believe that to be true. And they cite under the Masterpiece Cake Shop. I don't know what that case is, but I will look into it. On page 31, they throw it out. Based on the facts, there was no cross-examination to determine whether he selected statues for secular purposes or as he contended in his affidavit. So if litigation continues, the mayor, as the person solely responsible for selection of the statues, will be subject to further inquiry, including crucible of cross-examination, to determine this. So they gave him no benefit of the doubt there, and that feels very unfair. So I think the final statement here is pretty much also says everything. Judge Kafka wrote on page 34, the potential harm to the city is minimal. The building is open and functioning without the statues. The statues are safely in storage pending outcome of the litigation. There is therefore not a case where a preliminary injunction interferes with the government interest in any meaningful way. In sum, the public interest weighs heavily in favor of the preliminary injunction. I don't know about that. I mean, the judge has to consider, they have to balance the scale of harm, and the court said, hey, the city loses nothing by waiting. The building is open, working. Statues are safely in Randolph. Public interest favors just hitting the pause button, but they're forgetting about one thing: police and fire. Police and fire in their sworn affidavit have said that this is hurting their morale, that they want these statues, and they don't have them. So when you say that the city loses nothing by waiting, they do lose something. The people who are operating inside that building and working inside that building, the first responders who put their lives on the line every day, their spirit is suffering because those are the symbols for them. I just want to remind everybody that this is not a final defeat after a full trial. Like, there wasn't a full trial. They didn't say no. It was just the appellate court affirming that we need to, that there's a temporary pause. And it's just back to square one. It's going to be, bounced back to the Superior Court, and the lawyers are probably talking about it now. So we're just going to, again, have to wait and see. Let the statues rise, I say.